Assalamualaikum warahmatullahi wabarakatuh, and greetings to our respected lecturer, Sir Wan Yusra Rizal bin Wan Yusof. Today, my group would like to present to you the topic of the Capital Markets and Services Act 2007. Before that, I would like to introduce to you my group members. Our group member consists of 4 members, which are Farisha Binti Rahman, Fatin Farhana Binti Khairulhazaki, Tuan Shamshila Binti Tuan Shamrudin, and lastly, one Noor Shamimi Binti Ahmad Ikram, which is me. I will start our presentation with the introduction. The Capital Market and Services Act, or CMSA 2007, is a Malaysian Parliament Act enacted to combine the Securities Industry Act 1983 and the Futures Industry Act 1993. This Act governs and provides for matters pertaining to the capital markets, including markets and intermediaries, as well as matters incidental and consequential to them. The Act contains provisions governing mergers and takeovers of businesses, as well as legal remedies for victims of fraud. The CMSA 2007, as amended on September 15, 2015, is divided into 13 parts, each with 394 sections and 11 schedules. The CMSA 2007 is established to control issues pertaining to financial market intermediaries, markets, and activity. It also provides legal remedies for victims of securities offences and allows the Supreme Council to enforce administrative and civil measures. Last but not least, the CMSA 2007 is to preserve investors' rights while also maintaining the capital market's integrity and confidence.
The regulation and legislation under the CMSA 2007. Firstly, the Malaysian Code on Takeover and Mergers 2016. It is a set of regulations that govern the conduct of takeovers and mergers in Malaysia. The code was introduced to ensure that all shareholders are treated fairly and equally, and the event of a takeover or merger. It contains provisions that require bidders and target companies to comply with certain rules and regulations, including restriction on acquisition of share in the target company and the use of insider information. The code is issued by the Minister of Finance. The SC has responsibility for enforcing the code and has a direct responsibility for rulemaking and enforcing regulation pertaining to the capital market. This amendment includes restriction on dealing by persons who are not offered prior to the announcement of takeover offer, clarification in respect of preconditional announcement and preconditional voluntary offers announcement, and also the introduction in new conduct requirements that will apply in a whitewash exemption. The revision to the code and rules aim to provide enhanced clarity and alignment with takeover regimes in other key financial jurisdictions. Then the second one, the Capital Market and Service Prescription of Security, Digital Currency and Digital Token Order 2016, which came into effect in January 2019, defines the characteristic of digital currency and digital token. According to the definitions, digital currency and tokens which are not issued by any government or central bank and fulfill other specific features are considered securities. This order provides regulatory certainty and clarity regarding the treatment of digital currencies and tokens, ensuring that they are subject to appropriate regulations and oversight. The order is a part of the Malaysian regulatory framework aimed at addressing the challenges and opportunities presented by the growing use of digital currency and tokens. It also contributes to the protection of investor and integrity of the capital market. The Capital Markets and Service Act 2007 CMSA also plays crucial role in regulating the Malaysian capital market. The roles and functions of CMSA include: first, regulation of company takeovers and mergers. The CMSA ensures a fair and equal treatment of all shareholders during takeover and mergers by setting specific rules and regulations. The second, regulation of Unit Trust Scheme. The CMSA oversees all matters relating to the Unit Trust Scheme, including their establishment, operation, and compliance with relevant regulation. Third, licensing and supervision of capital market intermediaries. The CMSA requires all capital market intermediaries to hold a single capital market and service license, streamlining the licensing process and ensuring uniform standards across the industry. Next, supervision of exchanges, clearinghouse and central depositories. The CMSA is responsible for supervising exchanges, clearinghouse and central depositories to ensuring their proper functioning and compliance with relevant regulation. Then, encouraging self-regulation. The CMSA promotes self-regulation among capital market intermediaries, fostering a more transparent and well-regulated market environment. And lastly, ensuring proper conduct of market institution and licensed person. The CMSA ensures that market institution and licensed person conduct themselves in accordance with the provision of the CMSA and related regulation, maintaining the integrity and also stability of the capital market.
The Capital Markets and Services Act 2007 provides civil action and remedies for victims of securities crimes, aiming to protect investors' rights and maintain the integrity of the capital market. Some of the civil action and remedies provided under the CMSA 2007 include: first, civil remedies for fraud victims. Under the Act, victims of securities fraud can seek civil remedies in court. This includes compensation for losses, injunction to avoid future harm, and other equitable remedies. Second is regulation of company takeovers and mergers. The Act governs the process of corporate takeover and mergers, ensuring that they are carried out fairly and transparently. It also protects minority stockholders and stakeholders. Third is approval process for corporate proposals. The Act established an approval process for corporate proposals such as mergers, acquisition, and other major transactions. This process is designed to guarantee that transactions are in the best interest of the firm and its stakeholders. Fourth is product disclosure. According to the Act, all capital market products, including securities, derivatives, private retirement plans, unit trust schemes, and other securities or derivatives-based products must be accompanied by suitable product disclosure information. This information allows investors to make more educated decisions about the items they invest in. And lastly is enforcement of civil action. The Securities Commission Malaysia (SC) is in charge of enforcing civil action under CMSA 2007. The Supreme Court has the authority to undertake inquiries and investigations, and it may impose fine on persons found to be in breach of the Act. The Capital Markets and Services Act 2007 provides civil remedies for victims of securities crimes. According to the CMSA 2007, there are few main types of market misconduct or prohibited conduct in the securities market. First is false trading. This occurs when a person engages in deceptive trading practices such as creating a false or misleading impression of the market price or volume of a security. Second is market rigging transactions. This involves manipulative trading practices such as cornering the market, manipulating the market price, or creating a false market for a security. Third is stock market manipulations. This includes various manipulative trading practices such as trading ahead of a large client order or manipulating the market price of a security. And last but not least is false or misleading statements. This occurs when a person makes untrue or misleading statements about a security or the market, which can lead to investor confusion and make the market less transparent.
My name is Fatin Farhana Binti Khairulhazaki. So I will explain about the amendments to Malaysia Capital Market and Services Act 2007 in effect 1st July 2021. The Capital Market and Services Amendment of Schedules 5, 6 and 7, Order 2021, came into operation on 1st July 2021, with the exception in paragraph 3 in relation to part 3 of Schedule 6 and paragraph 4 in relation of part 3, of Schedule 7, which come into operation on 1 January 2022. The order amends Malaysia Capital Market and Services Act 2007. The order amends Malaysia's Capital Market and Services Act 2007 CMSA. The Capital Markets and Services Amendments Regulation 2021, which amend the fees set out in the Capital Markets and Regulations on 2012, also came into effect on 1st July 2021. So the amendments to the CMSA made by the order. The order makes the amendments to CMSA in Schedule 5 relating to the proposals that do not require approval or authorization or recognition by the Securities Commission Malaysia. Schedule 6 relating to excluded offers and invitations, and Schedule 7 relating to excluded issues of securities. So the salient provisions of the order as follows. Number 1. Schedule 5 of the CMSA now includes as an exemption the initial exchange offering of digital asset through a recognized market operator. Number 2. Schedule 5 of the CMSA is also amended to include the initial public offering or cross-listing of the shares of a public company or a listed corporation on a stock exchange outside of the Malaysia. Number 3. Schedule 6 and 7 of the CMSA now provide a wider definition of sophisticated investors to include, among others. So the first one is individuals with investment exceeding 1 million ringgit in capital market products, either on their own or through joint accounts with their spouse. Number 2, CEOs and directors of licensed or registered persons under the CMSA and corporations that manage funds of their related companies with assets of more than 10 million ringgit. So I will give 3 examples of amendment of Capital Markets and Services Act 2007 enacted from the Parliament Malaysia. The first example is deletion of Section 94. The Principal Act is amended by deleting Section 94. Next, amendment of Section 160. Subsection 162 of the Principal Act is amended by inserting the word refundable, the word except as may be specified by the Commission. And the last example is amendment of Section 219. Subsection 219(1) is amended by substituting from the word subject to subsection 217(5), the Commission, and by substituting for the words and any ruling made under subsection 217(4), the words guidelines, direction, practice notes, and any ruling issued by the Commission. So that's all from me. I will pass the presentation to the next presenter.
The Capital Market and Services Act 2007 is a significant piece of law because it governs Malaysia's capital market. It covers a wide range of topics linked to the capital market, such as the issuing and trading of securities, the behavior of market players, and the regulation of market intermediaries. It unifies the Securities Industry Act 1983 and the Futures Industry Act 1993. The Act also contains provisions for civil remedies for securities violation and for the regulation of corporate takeovers and mergers. By virtue of this Act, the Securities Commission Malaysia is designated as the principal capital market regulator. The CMSA seeks to guarantee the fairness, openness, and integrity of Malaysia's securities market. That is all from us. Thank you.